Alex. That was actually indeed very informative. So thank you so much. Is there any particular question? I mean, these are complex legal theories, and it's kind of unfair that Alex had to cover all of this in 15 odd minutes. So very well done on covering so much of that. But any particular question from the audience in this on this? All right. If not, there's one point that I'd just like to make. There is. Oh, sorry. So I didn't see that. I need my specs.
As Alexander said right now that the theory for joinder comes from various theories like piercing of veil, etc. My question is that these theories might be interpreted in various different ways across various jurisdictions. Keeping in mind that arbitrators might come from various jurisdictions and might have different theories about this, don't you think the applying of joinder of parties may be very ununiform right now because there not exists a single theory about it?
Exactly.
Absolutely.
Absolutely. I think yours is. I mean, there's a short answer to it. Yes. Right. And it kind of plays in well to the next session between Singapore and Hong Kong. Same case. Exactly the same case. Same set of facts. These guys say no. Oh, rather, sorry. These guys say no. These guys say yes. You know, it's a bit complicated that way. But the point that you made right now about it being not so uniform across jurisdictions, another important point that stems from that as well is, and linked to the last statement that Alex made about consent of parties being the very basis. You know, these theories like alter ego, group of companies doctrine, piercing of corporate veil, third-party beneficiary. I mean, my biggest gripe is actually with third-party beneficiary. Is the fact is, yes, there might be a group of companies, there might be, but the sanctity of the contract, that agreement. I might be benefiting from a contract, right? But I did not agree to the arbitration agreement. The agreement itself stands by itself. It's a separate agreement from the basic contract. So these theories, you know, and therefore you do not have uniformity. The biggest example is US. You have a case which is quite a famous case called Breda Sapik versus government of Turkmenistan. That case has gone back and forth between the Supreme Court and I can't remember the state. And they're just diametrically opposite views of two separate courts in the United States on it, you know, and United States and France, I think, have been the biggest propounders of these theories of group of companies and piercing corporate veil and so on and so forth. So yes, there is no uniformity, very true. Any other follow-up? Thank you so much for keeping that short, since we're running. Abhinav, you have a question? No, he doesn't.
We're short on time, but I can ask many questions, but I'll save that if we have some more time in the end.
All right, thank you so much for that, Abhinav. And now that point raised by the gentleman, sorry.
Utkarsh.
Utkarsh, oh, so very done. Nice.
Brilliant intern.
So thank you so much, Utkarsh. That is a good segue to our next jurisdiction, Singapore. Thank you, Smita.
Hi, everyone. First of all, I'm very conscious of the fact that it's 5 in the evening and you guys have been here the whole day. So we'll try and make this, I will try and make this as painless and short as possible. I'm from Singapore, and basically, I mean, what I'm going to talk about is this case has been going back and forth. Speaking of cases that go back and forth, Astro and Lippo. Just to check, has anyone here, apart from the panel, actually read Astro and Lippo? And this is not to cast aspersions at anyone because the case is over 100 pages long. And even for Singaporeans, it's hard to read. So I'm just wondering whether anyone
I'm sorry
here
to
has
interject
read.
there, Smita. This is an Indian audience. They're used to 400 pages.
Oh, okay. Alright, well, if you read 400-page judgments regularly, I wouldn't think you'd want to go on to read other jurisdictions' lengthy judgments. In Singapore, we're used to shorter judgments, so for us, a 100-page judgment is a big deal. So, just to check, has anyone here read Astro and Lippo? No? Okay, no worries, because I just want to know whether I should just give you guys a brief factual background. I mean, first of all, we sort of like tantalized you by telling you that Martin and I will be having a raging debate. I mean, there's a reason we're seated at opposite ends of this panel, because, and it's really Utkarsh's point, it's the same case, same issue, and two courts, the Hong Kong court and the Singapore court, looked at it very, very differently. So it's created a lot of excitement in the arbitration world, which is why we were going to talk about Astro and Lippo. But first, let me just tell you, so you have some context, what the position is under Singapore law when it comes to joinder and non-signatories. Basically, we're very conservative. Where the law stands today is that the arbitration agreement sets the parameters of the tribunal's jurisdiction with regard to joinder. And so the tribunal has no power to extend its jurisdiction to non-signatories. That's it. That's basically, it's that simple for us. And this was clarified or laid down or, really tattooed into our flesh with the recent case by our Court of Appeal, which is our highest court, of Astro and Lippo. And in Astro and Lippo, it concerned the Singapore International Arbitration Rules, SIEC rules. And in that rule, there was a rule which provided that the tribunal had the power to allow other parties to be joined to the arbitration with their express consent. So what happened there was the High Court read other parties to mean outsiders, non-parties, non-signatories. But the Court of Appeal said, no, there's a distinction between other parties, they used the word other parties, and third parties. And they construed this rule to mean that other parties meant you are signatory to the arbitration agreement, you're just not party to the arbitration that's going on the arbitration reference. They said there's a deliberate use of the word other parties and not third parties, which means really you've got no connection, you're not a party to the arbitration agreement. So that's basically where the Singapore position is. Let me just tell you what Astro and Lippo is about. It was actually a joint venture between a group of Malaysian companies, multimedia and TV services, that they were going to provide in Indonesia. That's what the joint venture was about. So Lippo is an Indonesian group of companies, and Astro is the Malaysian group of companies. And the joint venture was in 2005, and by 2008, parties started arbitrating. So what happened was, the Indonesians went first. They started court proceedings in Indonesia against several Astro parties. 3 of those parties were not signatories to the arbitration agreement. Okay, but they provided services to support the joint venture, and in the joint venture agreement, it was contemplated that these other parties would be providing those services. So they are part of that transaction, just to go in terms of concepts. And what happened was, Astro, when the Indonesian proceedings started, they immediately then started arbitration proceedings and tried to strike out Indonesian proceedings on the basis that, look, there's an arbitration agreement, you guys should be arbitrating in Singapore, because that's what the arbitration clause says. And at the same time that they started the arbitration, they also made an application to the tribunal to join the 3 non-signatories to the arbitration. And the tribunal ruled that it did have the jurisdiction to do so, and it issued a preliminary award on jurisdiction saying, yes, these parties are joined. And it was under that rule I read to you earlier, which said other parties can be joined with the express consent, and obviously these 3 Astro parties consented, even though the Indonesian parties, the Lippo parties said no. So what happened was, and this is where it gets interesting, after the jurisdictional award came out, under Singapore international law, which adopts the model law for the most part, you can basically challenge the tribunal's ruling on jurisdiction. So that's under Article 16.3, that sort of challenge, and the Lippo parties didn't do that. So they went ahead to the actual arbitration on the merits, and Lippo participated. I mean, they participated under protest. They basically said they reserved their rights on the jurisdictional challenge, but they didn't challenge the jurisdictional award to the supervisory court, which is the Singapore court. And when the award on the merits came out and Lippo lost, they didn't apply to set aside the award under Article 34 of the model law. So these are the 2 things which you will see was relevant to the Hong Kong court when it comes to conduct and concepts of good faith and that sort of thing. So then what happened was, basically, Lippo just did nothing. Actually, I should say the Lippo group of companies, because in all the cases they refer to them as First Media, because that's a relevant company. And a huge award was made against them, 250 million. And what happened was, enforcement proceedings started in several jurisdictions, in Malaysia, in the UK, in Hong Kong, in Singapore, and the Lippo group of companies did not resist enforcement in the UK, didn't resist enforcement in Malaysia, and in Hong Kong didn't bother visiting enforcement either. For a very good reason, they had no assets in any of these jurisdictions, so they didn't care. But then, when enforcement proceedings started in Singapore, what happened was there are assets in Singapore, and the liberal group of companies tried to resist enforcement by basically raising the argument of, look, you know, these parties who have an award against us were never signatories to the arbitration agreement, so sorry, I'm not going to pay them. And those three parties alone made up the bulk of the $250 million award. I think it was almost $170 million. So the High Court basically said, sorry, it's a one-shot remedy to challenge jurisdiction. Basically, after the tribunal made its award on jurisdiction, and under the Singapore rules, you've got 30 days to challenge that to the supervisory court. You didn't. It was a one-shot remedy, and you guys chose not to do it, not exercise it, so you've lost it. So too bad. And the High Court said no. And then what happened was they appealed to the Court of Appeal. And that's when the Court of Appeal released that really exciting 100-page judgment, where they said they overturned the High Court, and they felt that there was no absolute time bar. It wasn't a one-shot remedy. They basically had this concept of active and passive remedies under the common law, which they said applied in Singapore. And our Court of Appeal felt that this concept also exists under the model law when you look at the philosophy of the model law. And basically what that is the active remedy, meaning if you have lost, if there's an award made against you, your active remedy would be to set it aside or challenge it in your supervisory court, depending on what's provided for in your rules and your act. Your passive remedy would be to do nothing until someone comes to enforce against you, and then you defend it and you raise the jurisdictional argument. So what our Singapore court ruled, the Court of Appeal ruled, was that just because you didn't exercise your active remedy doesn't mean you've lost your passive remedy. You still have both. So practically what that means is you can do what Lippo did, which is basically go through the entire process, let Astro spend all the money and enforce everywhere. And in Hong Kong, they allowed enforcement and everything. And then when it comes to, you raise it at the very last moment when it comes to enforcement against you in a jurisdiction you care about, then you raise this issue of jurisdiction. So it really bothered a lot of people in the arbitration community that Lippo did not apply to set aside the award or challenge a jurisdictional award, but yet the Singapore court didn't allow enforcement of the award on the basis of this jurisdictional issue, which is that of joinder. So basically, the Singapore court, coming back to the issue of joinder, the Singapore court made very clear that there are certain reasons for denying the joinder here. And it was the tension, the traditional tension that Alex mentioned in terms of concepts, and you would have heard and seen over and over again. The tension between the principle of party autonomy, which underlies the whole consensual nature of arbitration, and maintaining arbitration's practical effectiveness by bringing related parties together and being fair and making sure justice is done and so on and so forth. And for Singapore, which is traditionally a jurisdiction which is very big on effectiveness and that sort of thing, this came as a surprise to many people because we thought the Court of Appeal would basically scold Lippo and say, nice try, but go away, right? So, but what our Court of Appeal did instead was they upheld the principle of party autonomy, and they said that arbitration, they went back to the traditional principles. It's a private consensual process, and consent is always a necessary condition. It's the very foundation of arbitration, and it doesn't matter how connected the non-signatories were to the matter, and how it made a lot of sense to avoid duplicative parallel proceedings. If those parties did not elect for arbitration for their dispute, then too bad. They can't be joined. So the Court of Appeal actually said that legitimate advantages and procedural effectiveness which would be gained with a forced joinder will not, in and of themselves, provide a Singapore court with the authority to derogate from the principle of party autonomy. So that's where our law stands with regards to joinder. It's very strict and it's very clear now. So essentially, if you want to be joined to the arbitration, you obviously have to be a party to the arbitration agreement. Or the arbitration agreement is extended to you and everyone has to agree. So not just the parties to the arbitration agreement, but the party that is going to be extended to has to consent to accept it. So basically extending it. And then you get to the more controversial territory, which is implied consent, which came up in a sense in Astro and Lippo, because another argument which the Astro group of companies raised, was that of waiver or implied consent. And the court, and I think I'll wait till Martin talks about the Hong Kong judgment on good faith, because I think essentially the way Hong Kong approached it, by looking at good faith, Singapore approached the same thing but looked at it from the principle of waiver, because I think they worked backwards. Knowing what they wanted the end result to be, they worked backwards and they said waiver, the threshold is very high, and so, sorry, you don't meet it. So essentially, that's basically the position in Singapore. And since the Astro and Lipo case, we've had another 2 cases which are of some relevance, where they basically reiterated the principle of party autonomy. And one case, which I think Akshay and I were discussing earlier, is that of Titan Unity, where the court went a bit further and they basically said that this whole issue of joinder would be within the tribunal's jurisdiction, because in that case, the parties' arbitration agreement provided for arbitration rules which did provide for joinder of non-parties. And so the court felt that, look, it's the arbitrators and the tribunal that should decide this issue and not the court. So even though the court felt in that case there was implied consent to be a party and they would definitely should have been joined in the proceedings, the court felt that it's not my place to do it.
I actually think that case is really funny, because the judge actually goes ahead and says there is implied consent and therefore the party should be joined. But I'm not saying that. Let's go back to the arbitrator and let him decide this.
Yes, that's right. So that case is basically seen to be, you know, hey, we're really upholding the competence principle and that sort of thing. So there was another case, Lufthansa, but I think that's not of so much interest to anybody. We can just come back to Astro and Lipo. Just to give you the heads up on the Hong Kong situation. So what happened was, in Hong Kong, Astro did register, get leave to basically enforce the award. It was registered as a judgment, and under the Hong Kong regime, which Martin is obviously more familiar with, I think they had a limited number of, a short period of time within which you had to appeal that or challenge that, and they didn't. And I think with that, I can hand over to Martin.
Actually, before I hand it over to Martin, there are 2 important points that I'd like to make in relation to Astro Lipo Singapore proceedings, because that will kind of be a nice segue to Martin, plus it'll add to the discussion later on. Could you just go down 3 slides? Yeah, that's it. What Astro Lipo also did was get SIAC to look at its rules on joinder of parties, and SIAC amended its rules. Was it 2010?
Yeah, 2010.
And it basically added, upon the application of a party, allow 1 or more third parties to be joined in the arbitration, provided that such person is a party to the arbitration agreement. So this bit was amended by the SIAC. It was quite an impact. And the second point, which leads to good faith or the doctrine of, I mean, it did look at estoppel, didn't it? It looked at...
it was in their ordinance, this good faith doctrine.
Yeah, the good faith doctrine was as far as Hong Kong is concerned. But that actually relates to the New York Convention, and really what the Singapore court judgment threw up is the interplay between the active remedy and passive remedy. The active remedy actually comes from the ancestral model law, and the legislations of different countries which follows ancestral model law, whereas the passive remedy is completely separate. So in the Indian context, the active remedy comes from part 1 of the Act, whereas the passive remedy comes from part 2 of the Act. You know, and in an international arbitration scenario in India, you won't even get a part 1 remedy anymore. So hopefully, yes. So this active passive. Now that has thrown up a question which the international arbitration community needs to look at, is how do they interplay this active and passive remedy? And now over to Hong Kong to discuss how passive remedy would not be allowed if active remedy wasn't accessed.
Thanks very much. Well, I'm going to leave the Astro and Lipo case hanging tantalizingly just for a few minutes, and return to institutional rules, actually, given what's just been said about the SIAC rules. There are 3 brief points that I'll touch on in relation to the Hong Kong perspective. The first is the joinder provisions of the Hong Kong International Arbitration Centre rules. The second is the general position on joinder and non-signatories under Hong Kong law, and then I'll circle back at the end to discuss the Astor against Lippo judgment, the very interesting recent judgment of the Hong Kong Court of First Instance. Starting with the HKIAC rules on joinder, these tell an interesting story actually, because much in the same way that the SIAC rules were amended in light of the Astor against Lippo litigation, the Hong Kong rules have gone through quite an evolution. The old version of the Hong Kong rules had a very simple joinder provision, which was based on the old LCIA rules. And it essentially provided that a third person, that was the phrase that was used, could be joined to an arbitration in circumstances where the third person and the party applying for joinder both agreed, both consented. It was a fairly limited provision. The latest version of the HKIAC rules is the 2013 version, which came into effect in November 2013. And those introduced a much more detailed provision on joinder. It's actually 3.5, nearly 4 pages long in the HKIAC rules. And it's one of the most, if not the most detailed provisions. And it was deliberately designed to address many of the issues that have come up in other instances, and including in the Astor against Lippo cases. The basic principle is that an existing party or an additional party can apply to be joined to an arbitration. And that joinder application can be made either before the constitution of the tribunal or after the tribunal has been constituted. There's a procedure in place in the rules for the parties to make a joinder request and a reply to the joinder request, much in the way of a request for arbitration and an answer to the request for arbitration. And then a decision is made, the basic principle being that if the additional party is prima facie bound by an arbitration agreement under the HKIAC rules giving rise to the arbitration in question, then they may be joined to the arbitration. Now, I just want very briefly to touch on a few of the issues that raises, because there are a few interesting aspects of those rules, some of which will be familiar from the ICC rules, and some of which are slightly different. The first key point is that this is a default provision. It applies automatically to all arbitrations commenced under the HKIAC rules, the 2013 version. And in practice, that means all arbitrations commenced after the 1st of November 2013. That's different actually from some of the other provisions for complex arbitrations in the HKIAC rules. For example, consolidation, where the arbitration agreement in question needs to have been agreed after the rules came into force. That's not the case though for joinder. Any arbitration to which the 2013 rules apply, the joinder provisions will apply automatically. The second and related key point is that they do away with the need for consent. The parties agree in their arbitration agreement to incorporate by reference the HKIAC rules, and those contain the consent to joinder. There's no need in the arbitration agreement or anywhere else after the event arises to consent to joinder. Between them, those are actually provisions that have attracted quite a bit of comment, and there has been some suggestion that they are provisions that give rise to an element of controversy. I won't get into them now. I'm certainly not here to either advocate for or defend the HKIAC rules, but something we can possibly return to in the questions. The next key point I wanted to mention was that the rules make crystal clear that joinder only applies to parties to the arbitration agreement. So this is not a scenario where a stranger to the arbitration agreement is going to be dragged into the dispute. The party being joined must have signed up to the arbitration agreement in the first place. The rules are also, although they're titled joinder, are really provide for joinder and intervention. It's not only that a party may be joined, but actually that a party may volunteer itself to take part in the arbitration, even if it wasn't the subject of the original notice of arbitration. As I've mentioned, that can all happen either before the constitution of the tribunal or after the constitution of the tribunal, and that's quite a key development because previously It was the HKIC's hands were tied. Joinder could only happen after the tribunal had been constituted, and the tribunal itself would make that decision. That's no longer the case, and the HKIC itself can make a decision on joinder before the tribunal has been constituted. That does give rise to some interesting issues in relation to the appointment of arbitrators, and the rules do contain some provisions which are designed to deal with those. The converse point is that there's no long stop date for a request for joinder. Technically, you can make a request for joinder at any stage in the proceedings. The reality is, of course, that the longer you get through the proceedings, the more difficult it's going to be to justify a request for joinder. So really, a party applying for joinder or wishing to intervene in an arbitration should always be making that application as early as possible after they learn of the existence of the proceedings. Next point but last, this is a discretionary rule. So if the application is made to the HKIC before the tribunal is constituted, or to the tribunal, it's at their discretion whether or not to join a party. They don't have to do it. They can decide whether the circumstances are fitting for joinder to take place. And finally, there is a deemed waiver by the parties of their right to object to the joinder, to the award as a result of the joinder of a party. And that does not mean that the parties aren't entitled to challenge the award on the basis of jurisdiction, but it does mean that they can't complain about the fact of the joinder itself. That, in a nutshell, is the provision under the HKIC rules, and as I've said, it does have certain similarities with the ICC position, and there are also some areas where it departs. The second point I wanted to touch on very briefly is the general position under Hong Kong law, and I think all I need to say on that is that, as Smith has said in relation to Singapore, Hong Kong is also fairly conservative on this point. The doctrine of privity of contract reigns pretty much supreme, and the circumstances in which a party who is not a signatory to the arbitration agreement may be bound by it are very, very limited. And they're the types of scenarios such as agency, assignment, or piercing of the corporate veil that have already been mentioned. There is a provision in Hong Kong law now for third parties to have rights under the rights of the contracts rights of third parties ordinance, which was introduced essentially to try and replicate the position on third party rights in English law and under Singapore law. That was passed at the end of last year, but it hasn't come into force yet. It's expected that that will come into force towards the end of this year. Right, in the spirit of leaving the best till last, I'll come back to Astra against Lippo, and this recent decision of the Hong Kong Court of First Instance that has already been mentioned. The first point I want to make about this is that there's an important point about the scope of the case. This is not a case which decides the circumstances in which a third party will be bound by or will be entitled to rely upon an arbitration agreement. The court in this case actually wasn't entitled to make that decision, and it recognized that the Singapore court had made a final and binding decision on whether or not the tribunal had jurisdiction, and that issue of the tribunal's jurisdiction was therefore re judicata in the Hong Kong proceedings. So what the Hong Kong court was not doing was deciding whether in fact the tribunal had jurisdiction. And in fact, the CFI acknowledged very clearly that the tribunal did not have jurisdiction in accordance with the Singapore court's ruling. Just to take a step back and explain how this decision arose, I just want to go into a little more detail about the Hong Kong enforcement regime that Smith mentioned. Basically, the starting position in Hong Kong is that an award is binding and should be enforced unless one of the Article 5 New York Convention grounds can be made out, and those grounds are incorporated into the Hong Kong arbitration legislation. And they obviously include lack of jurisdiction or want of jurisdiction, excessive jurisdiction, amongst the other grounds. The principle is that if one of those grounds is made out, then the court has a residual discretion as to whether or not to enforce the award or decline to set aside the award. It can ultimately decide. But that's subject to an important caveat, which Smith mentioned, and that's this issue of good faith. If the party who is seeking to resist the award is deemed by the court not to have acted in good faith, then the court can decide to enforce the award even though one of the Article 5 grounds for resisting enforcement has been established. That's to say, it can enforce the award even if, in this case, for example, the tribunal had no jurisdiction. The factual background to the Hong Kong litigation, as Smith alluded to, was that enforcement proceedings were taken by the Astro parties in various jurisdictions, including Hong Kong. And a conscious decision was taken by First Media and Lippo at the time not to contest the recognition and enforcement of the award in Hong Kong. And they did that for the understandable reason that, as far as they were concerned, they didn't have assets in the jurisdiction. In the meantime, the Singapore proceedings were rumbling along, and they ultimately gave rise, obviously, to the Singapore judgment that Smith has mentioned. Things changed in Hong Kong when Astro learned that a payment was due to be made by First Media's parent company, an entity called Across Asia Limited, to First Media, and it actually amounted to about 44 million US dollars, so it was a very substantial proportion of the overall award amount. And proceedings were launched in Hong Kong to garnish those sums, essentially to divert the sums that were due to be paid from Across Asia Limited and ensure that they were paid directly to the Astro companies as beneficiaries of the award. Those proceedings were resisted, obviously, by the Lippo companies, and that's what gave rise to the judgment of the Hong Kong Court of First Instance. What it really had to decide was whether or not to go ahead and enforce the award. And the ultimate judgment of the court was that it would do so. It would allow enforcement. And it did so, as I've said, despite the fact that the tribunal had no jurisdiction, and it acknowledged that. Now, there were two key reasons for that decision. The first, Smith has alluded to, purely procedural. The Lippo companies were out of time under the Hong Kong regime to try to resist the recognition and enforcement of the awards. They'd already been converted into Hong Kong judgments, and actually the time limit had passed 14 months previously. So the judge held that on that basis alone, they were not entitled to resist enforcement. But he went further and he held that they also were not entitled to resist enforcement because of a lack of good faith. And this relates to that Hong Kong principle that you can resist enforcement if you're deemed to have acted in good faith. What the judge found was that in this case, the Lippo companies proceeded with the arbitration after the tribunal's jurisdictional ruling. They didn't exercise their primary or active remedy to seek to set it aside. At one point, the tribunal actually asked the Lippo parties, is there any challenge to our award in Singapore? And counsel for Lippo said no, there was not. And they went on to participate in the merits hearing, and the award was subsequently rendered. And the judge held that on that basis, the Lippo parties had not acted in good faith, and they were not entitled to resist enforcement of the award. There's a lot of interesting issues to come out of that judgment, so I won't get into too many of them now, especially given the time. I think we can probably discuss some of them in the questions if we've got time. But I just wanted to tee that discussion off by saying that the judge's decision does arguably go further than the previous Hong Kong decisions on which he relied. And there's a school of thought that the decision of the Court of First Instance does give rise to a degree of uncertainty now in Hong Kong as to what exactly a party needs to do if they challenge jurisdiction before the tribunal, and the tribunal nevertheless accepts jurisdiction and proceeds to render an award. There's potentially a degree of uncertainty as to what exactly the party claiming there isn't jurisdiction must do in order to be in good faith under the Hong Kong regime. I'll leave it at that for now, given the time, but obviously very happy to speak further about those issues and questions and discussion.
You've just stolen my question. My question was, if I have to enforce an award in Hong Kong, would I need to first resist an award actively, or have I forgone it forever, as far as enforcement in Hong Kong is concerned? But there's another another question that I have, which relates to the HKIAC rules that you were referring to earlier. You know, the waiver under the HKIAC rules. So if a party doesn't resist, once the tribunal includes a non-signatory, there's an implied waiver. Doesn't that in some way conflict with this enforcement under New York Convention and the ability to actually resist enforcement, because because the award technically is in breach of the law of the choice of party, the law of choice made by the parties?
I think that it's an interesting question. There's definitely scope for argument along those lines. Where I think the distinction would be drawn with the HKIAC rules is that you're not dealing with a non-signatory per se, you're dealing with a party to the arbitration agreement who consented to HKIAC arbitration in the first place. I mean, actually, I think the question's really interesting because it goes to one of the criticisms of the HKIAC rules that I mentioned earlier. It is sometimes said that this is an unfair default provision because it basically means that people can be joined to an arbitration without having actually agreed to that joinder. Personally, I tend to take the view, I think that's a slightly churlish complaint because, as I've mentioned, the joinder provisions only apply if a party signed up to the arbitration agreement. So for a party to complain that being subjected to HKIAC arbitral proceedings at the end of the day is somehow beyond its legitimate or reasonable expectations doesn't seem to be particularly credible. That party consented to HKIAC arbitration, and under the rules, it's been joined to an arbitration. That's arguably not something that would not have been contemplated when the arbitration agreement was signed.
So just to clarify, and this is more my personal clarification, I think here for a minute, is if the tribunal applies some form of pierce the corporate wheel doctrine or something of that sort to join a non-signatory, then this so-called waiver would not apply automatically.
Yes, absolutely. The waiver is specifically and expressly in relation to joinders under the relevant article of the HKIAC rules. So if the tribunal have done something that goes further and they've joined a party that actually didn't sign the agreement, then that deemed waiver does not apply.
Thank you so much, Mark.
And what happens if one of these parties actually do not take part in the proceedings? One of these parties who signed the agreement and have been later joined under the HKIAC rules but do not take part in the proceedings at all. And the tribunal, I imagine, would be expected to take a decision on the jurisdiction because they are not participating. How do you, have you seen something of that sort where the enforcement could be then resisted on the ground because of non-participation later?
I think that's really interesting in light of Astor against Lippo, because what the Astor against Lippo decision suggests is that you really need to be conscious at every step of the way as a party resisting jurisdiction, resisting enforcement, that you are not only telegraphing to the tribunal that you object to jurisdiction, but equally and on the other hand, that you're acting in a way that the Hong Kong courts would consider to be in good faith. And the suggestion, I think, coming out of the Astro Hong Kong judgment is that if the jurisdictional award goes against you, then essentially your duty, under the general duty to arbitrate in good faith, is to proceed with that arbitration, to participate, and to ensure that despite your protestations about jurisdiction, you nevertheless take part and see the process through to a conclusion. So I absolutely agree that there's a real conflict there, potentially, between a party doesn't, who on the one hand takes the position that there is no binding arbitration clause which binds them, but on the other hand, in light of the good faith principle, essentially feels compelled to have to take part as fully as possible in the arbitral proceedings.